This feels like more than just a company struggling with debt. It looks like a business model almost built to dodge obligations, to leave people behind. Like a corporate magic trick, but, not magic, just strategy. Remember what Cliqly always talked about? Their big asset, that huge email list, 31 million subscribers.
That was their core value proposition, right?
Yeah. Exactly. The bedrock of the whole thing. The engine, they said, drove the commissions you were supposed to get. Their crown jewel. Now, what's really stunning here is the timing and the public nature of the transition. For months before that June 9th bankruptcy filing, the owner of DE Marketing LLC, the company now claiming it's broke, was openly talking about moving the business to a new sister company. And this new company, doing the exact same thing, email marketing, this is Clicker, often pushed alongside MyInbox Pro, Push Platform, other related names. So to everyone on the outside, to the members, it probably just looked like a rebrand, maybe an upgrade, not a company secretly planning to liquidate while owing millions. It really seemed like business as usual.
And connecting those dots, this isn't just a simple rebranding exercise from a legal perspective. Companies can't just file Chapter 7, claim they're ceasing operations, and then pop back up with the same assets, same business model, new name, without serious legal questions being asked. Especially websites. Websites like Cliqly.com, conversionhousemedia.net if they're active, generating leads containing customer data like a massive email list. They are absolutely assets in bankruptcy.
Valuable, right?
Extremely valuable. Their continued operation, while the parent company claims to have nothing, isn't just significant. It's like a giant flashing sign pointing to potential problems. And here's the really damning part. As of June 21st, 2025, that's after the bankruptcy was filed, those websites, Cliqly.com and conversionhousemedia.net, were still live, still running.
Wait, after they filed bankruptcy, the old sites were still up?
Yes. Fully operational, accepting new signups, promoting services, likely still bringing in revenue, all while DE Marketing LLC is telling the bankruptcy court it has virtually no assets. We actually have direct proof of this continuity. A screenshot from inside the Cliqly member area system.cliqly.com. It's actively promoting Clicker, right there on the dashboard.
What does it say?
It calls Clicker the all-new Cliqly Clicker platform. Not subtle at all. It even boasts that Clicker launched after paying out over $38 million with Cliqly, trying to link the new venture to the old one's supposed success. It promises users they can make up to $1,500 with a daily payout system, just portraying seamless business as usual as if the bankruptcy is irrelevant. And the promotional video, it features Bobby Jones, almost certainly the same owner, showing clear continuity of leadership, branding, everything.
Wow, so it's not even hidden.
Not really, no. And the timeline is just critical here. Clicker launched on May 1st, 2025.
May 1st, and the bankruptcy was June 9th.
Exactly. Just 1 month before DE Marketing LLC filed Chapter 7. That timing doesn't feel accidental. It strongly suggests a planned move.
Like moving the valuable parts over before declaring bankruptcy.
It points directly towards a premeditated asset migration. Shifting the core business, that huge email list, the platform structure, the contractor network to a new company right before trying to shed the old company's debts through bankruptcy. And adding to this, the official Cliqly Facebook group, it's still active, still promoting Clicker. People are posting about getting paid by Clicker in there, so you have this facade of success and continuity while the huge debts from the old company are just ignored in the bankruptcy filing.
That just seems wrong.
It's more than just wrong ethically. It raises serious legal issues. It looks like potential asset concealment, using property that should belong to the bankruptcy estate to fund a new venture. It's misleading creditors. It might even be seen as making preferential payments to new Clicker affiliates, giving them money or opportunities that should legally go towards paying off the old debts owed to people like you. Legally, this whole pattern screams potential fraudulent transfer. That's covered under Section 548 of the Bankruptcy Code. It deals with transferring assets for less than their worth or with intent to defraud creditors, often to related companies or insiders.
Like moving the email list to Clicker.
Precisely. That 31 million list, the website infrastructure, moving that to Clicker fits the pattern. It could also lead to successor liability.
Meaning Clicker could be forced to pay Cliqly's debts.
Potentially, yes. If the court sees Clicker as just a continuation of DE Marketing's business using the same assets, they could hold Clicker responsible for the old debts. Ultimately, all of this points very strongly towards potential bankruptcy fraud under federal statutes 18 U.S.C. Section 152 or Section 157. This isn't just a business failing. It really looks like a calculated attempt to evade legitimate debts and leave thousands unpaid.
Okay, this whole picture is just incredibly frustrating, especially for anyone who's been patiently waiting maybe for years for commissions they earned. But knowing all this now, understanding what seems to be really going on,
Yeah.
what can people actually do? Is there any real way to fight back, to try and get what's owed? The good news, maybe the only bit of good news here, is yes, there are definite steps you can take. And crucially, remember this, if you're an unpaid 1099 contractor, the law sees you as a creditor of DE Marketing LLC. You have rights in this bankruptcy process.
Okay.
And don't underestimate the power of numbers. There are over 3,000 of you, owed over $2 million collectively. That's significant leverage. You're not fighting this alone. And together, your voice is much, much louder.
That's right. And it leads to the key question. What specific legal tools can creditors use in a situation like this? Especially when it looks like assets were hidden and creditors were deliberately left off the list. There are several concrete actions. First, and this is immediate and critical, notify the Chapter 7 trustee. His name is Ronald J. Summers. You absolutely need to tell him, formally and with evidence, about the thousands of creditors who were omitted. And just as importantly, show him the proof that assets like the websites are still running and that Clicker is being actively promoted using essentially Cliqly's infrastructure and branding.
How do people do that?
You
send an email.
You need to be organized. Gather your evidence. Copies of your 1099s, screenshots showing unpaid commissions on your dashboard, any emails you have promising payment, and definitely that evidence of Clicker being promoted on the Cliqly platform. Present it clearly. The trustee has a legal duty to investigate the debtor's assets and liabilities. Getting clear, verifiable evidence from a large group of creditors puts pressure on him to act. You're essentially handing him the leads to follow. Second, there's a very powerful tool called a Rule 2004 examination. It's part of the Federal Rules of Bankruptcy Procedure. This allows for a really broad investigation into everything about the debtor, their actions, their property, their finances. People sometimes call it a fishing expedition because you don't have to prove fraud first. You just need a good reason to investigate.
So you can dig deep.
Very deep. It lets you ask the court for permission to subpoena documents. Think bank records, logs showing where money or assets went, records about who really owns that 31 million email list, Clicker's financial records. It also allows for depositions. That means people like the owner, officers of DE Marketing, maybe even people running Clicker, can be forced to answer questions under oath.
Can individual creditors ask for this?
Yes, creditors can request it. Often it's done through lawyers, but if the trustee isn't acting, a group of creditors can file a motion directly with the court, explain why this broad investigation is necessary given the circumstances. Third, you need to focus on proving hidden assets and fraudulent transfers. This means carefully looking at the public bankruptcy documents, Schedule AB assets, and the Statement of Financial Affairs. Look for inconsistencies. Look for signs of fraudulent transfers. That's where assets get moved to insiders, related companies, or sold cheaply to keep them away from creditors. The transfer of the email list and business operations to Clicker. That's exactly the kind of thing covered by Bankruptcy Code sections 544 and 548.
And connect it back to their initial claim of only $50 in assets.
Exactly. That claim seems completely at odds with the value of a 31 million subscriber list and active websites. That discrepancy alone should force the trustee to investigate. If a transfer is found to be fraudulent, the court can actually reverse it, claw it back, bringing those assets back into the bankruptcy estate to potentially pay creditors like you. Fourth, there's a strategy called piercing the corporate veil or arguing successor liability. This comes into play if you can show Clicker is just DE Marketing under a new name, run by the same person, using the same assets, doing the same business. If you can prove that, you might convince the court to ignore the separation between the companies and either hold the owner personally liable for DE Marketing's debts or make Clicker responsible for paying them. It's complex but possible in cases like this. Fifth, remember your right to request financial records and be notified. Companies in Chapter 7 must give the trustee all their financial records, ledgers, bank statements, P&L, and yes, affiliate payment records. Hiding them is a serious violation. While you don't automatically get to see these internal records, you can push the trustee to examine them or use that Rule 2004 examination to force their production. And critically, since you were likely left off the initial creditor list, you should file a simple mailing matrix request with the bankruptcy court. This tells the court, I'm a creditor, add me to the official mailing list.
So you get notified about hearings and deadlines.
Exactly. It ensures you receive all the official court notices you were initially denied. It's a simple but vital step to protect your rights. And finally, if the Chapter 7 trustee seems unresponsive or isn't acting quickly enough given how blatant this seems, you can escalate. You can contact the U.S. Trustee's Office. This is a federal office that oversees bankruptcy cases. They investigate fraud and abuse. A coordinated complaint from many affected creditors with solid evidence can definitely get their attention and potentially force action. It's an important oversight mechanism.
So after digging through all of this, what does it really mean for you, the listener, if you're one of the thousands still waiting for that Cliqly money? This isn't just about learning legal details. It's fundamentally about knowing your rights and understanding there are ways to potentially recover what you're owed. But it requires you to take action. Let's quickly recap what we found. A quiet bankruptcy filing. A shockingly low creditor count that just doesn't match reality. An active sister company, Clicker, launched suspiciously right before the bankruptcy. Strong evidence that valuable assets, the email list, the websites, were moved from the bankrupt company to the new one. And all this while the Cliqly Facebook group acts like everything's fine, promoting Clicker, celebrating new payouts. It's almost like gaslighting the people who owe money. The urgency here is real. If you don't step up and make noise, this case could easily get closed as having no assets available. No real investigation happens. And if that occurs, the owner could potentially just walk away from millions in debt, leaving you and thousands like you with nothing.
And worse, they could just keep running the same business under the Clicker name, maybe even do it again later. This is why collective action is so vital. It's not just helpful, it's necessary. The more people who contact the trustee, file requests, share evidence, the harder it becomes for the system to ignore what's happened.
Exactly. And knowledge, like we always say, is only powerful when you use it. This whole situation really drives home how important critical thinking is, especially now with so much information and often misinformation out there. You have to look beyond the surface. It's not just what the documents say, it's about what they don't say, what's missing, what's happening behind the scenes that they don't want you to see. I mean, this whole scenario, the quiet filing, the immediate launch of the new brand using the old assets, it doesn't look like a typical business failure. It really does suggest a deliberate planned strategy to ditch debts. It's almost a playbook for how a company might try to get out of its obligations while keeping the valuable parts. It's deeply concerning for accountability in the digital economy. So here's a final thought, something for you to really consider after this deep dive. How often does this kind of thing happen? Companies try and use bankruptcy to just disappear their debts while relaunching almost unchanged. And what does this specific Cliqly Clicker case teach us about the absolute need for us to be vigilant, to be informed, and, most importantly, to take coordinated action when things don't add up? This isn't just about one company, it's a lesson for navigating the whole digital marketplace. If you know anyone else affected by Cliqly or DE marketing, please share this information with them. It could make a real difference.
Thank you for joining us for another really crucial deep dive. We genuinely hope that understanding this complex and, yes, infuriating situation gives you some power back. Staying informed, especially when things get complicated like this, really is your best defense.
Absolutely. Corporate accountability isn't guaranteed, especially online. It often requires people who are affected to stand up, use their knowledge, and take action.
Until next time, keep digging, keep asking questions, and always, always look beyond the hype.